Assalamu alaikum, good evening viewers. Welcome to Legal Ease, where we make the law easy for you. This evening we're going to continue with a guest we had previously, Advocate Ghulam Amir. He's here to talk about some aspects of the law. And please be ready with your questions. We will open the lines after the first break. Ghulam, Jazakallah for making yourself available, and thank you for being here again. The last time we had some unfinished questions. Viewers called in. We've managed to answer some of their questions. We've got a few questions. We're going to talk about them. One thing that always comes up, but before we do that, Ghulam, just in case some of the viewers haven't seen you earlier, maybe just a short introduction. Tell us a bit about yourself.
Jazakallah. Assalamu alaikum. The name is Ghulam Amir. I'm practicing at the Johannesburg Bar as an advocate for some time. But I think let's rather get on with the questions, because the last time we had a very short period. And there wasn't enough time for the question and answer session. So we're going to keep it short on the discussion that we have, and inshallah then we'll open the lines to give the viewers an opportunity to ask questions.
Okay, let's start off with one that we were about to start the last time when our time was up. And this is the one about a compulsive buyer, and I think this affects a lot of people.
Yeah.
Viewers, I'm sure some of you have been in this situation. Compulsive buyer, person buys more than what they can afford. For example, somebody earns 20,000 rands a month, buys an expensive item like a car for 15,000, goes to the bank for a loan. The bank doesn't ask too many questions, grants the loan. The person now goes out, buys the car, and then of course can't meet the payments.
Yes.
Then the bank wants to claim assets from the person. What are the person's rights?
Yes. You know, traditionally the credit system in this country, and in every country, it's a universal problem, has been the means of destruction of people's lives. Classic case, the example you give, a person earns 20,000 rand a month, goes past and in the flick of the moment is tempted to buy a BMW where the installment is 15,000 rand a month. He's got school fees to pay, he's got all sorts of other expenses, and not surprisingly, within a few months, he then can't afford to pay his installments. Of course, then the bank institutes action, takes a judgment. His house is at risk, his assets are at risk, all of those issues. Now, as a result of this kind of abuse by the industry, the banking industry, the credit granting industry, we will call that, and the dealerships, such as motor dealers, furniture dealers, etc., there was an act that came about some time ago. It's called the National Credit Act. The National Credit Act created a framework of law which basically prevented that kind of abuse, taking advantage of the consumer by the banks and the dealerships. So one of the things that it has imposed in terms of statute is it imposes a positive obligation and a responsibility upon the credit grantor, that's the bank, and in fact the dealership who acts as their agent in that capacity, to in fact do a full investigation, a full question and answer session. There's mandatory documents they've got to fill in to establish whether you in fact fulfill the means criteria. So for example, they have to take a statement from you as to what you earn, what your expenses are, things like your lights and water, your monthly other credit card expenses, etc. And once they do that, they have to do an affordability test. And after that, if they feel that you are able to get the funds, they can then advance you the fund, and they must be satisfied that you'll be able to repay it without difficulty. If they don't do that, there's a section in the Act, Section 80. It's called reckless credit. And if you are given credit under circumstances where you ought not to have been given credit, it constitutes reckless credit. And if they sue you as a result of a default of your obligations based on that credit, the laws come back quite harshly on the credit grant to the banks, where in fact in some instances there's a forfeiture of the amount that you owe them entirely. So those are the issues. The law that's now come about is to prevent that kind of abuse.
To protect the person against themselves, I suppose.
That's exactly it, yeah.
And a case like this, clearly, I mean, earning 20,000, buying something for 15,000,
yeah.
5,000 is not enough for somebody who's got a car, let
Sure.
alone a house and a family to support.
Sure, and eventually this was actually happening on a very large scale, particularly in the bond market. The banks were just giving bonds left, right and center. After a person pays for a couple of years, then they foreclose. And you lose what you've paid, you lose the house, and that was what was happening. So to protect the consumer, this act has actually come about.
Okay. But clearly that's unethical behavior on the part of the banks,
Yeah,
because
and
they
that's
know
why-
you're going to default. Right?
That's why the legislature has stepped in to prevent this kind of abuse.
Okay, another one that often people talk about often, and many people are involved in this. I mean, you drive your car and suddenly there's an accident, somebody drives into you, and you in a daze, and these tow truck guys come up and pull up there, and they say, you know, we need to clear the road, and you look at the guy and you say, okay, and you sign without really knowing what it is, and he says it's going to be 500 rands, and the day you go and claim your car from the tow truck, and viewers, and maybe some of you were involved with, you go and claim your car, and they say, wait, hold it, 500 was for the towing, but if you read the fine print, you'll see we kept your car in storage, there was security involved, and suddenly instead of 500, you know, it's a few thousand rands.
Yes.
What are your rights in a case like that?
Clearly, the conduct is unethical from a moral point of view.
Right.
But the question is whether it's legally problematic, because that's where your rights now lie.
Especially since you've signed that document,
Yes.
and it may be there in fine print.
Generally, whatever you sign in that document permits them to take the vehicle away to a place of storage.
Right.
Now, they have an obligation and a responsibility in law to charge you for your reasonable tow costs, whatever that would be, and a reasonable storage charge. They're entitled, particularly if you've signed that. But, of course, in the case that you've mentioned now, and it often happens, the unscrupulous tow truck drivers and companies, what they do is they, in fact, hold you hostage. Because they've got your car, they now want 10 or 12 or 15,000 rand at the end of a weekend. Clearly, it's unreasonable. What are your remedies in such an instance? In such an instance, you can go to court on an urgent basis, and I've had one or two cases like this where we were successful, and you say to the court, this is unreasonable, that is my vehicle, I'm disputing the amount that he's claiming, and because he's holding your vehicle as a lien, which he's entitled to do in law if you owe him the money,
Right.
provided it's valid, until the dispute is determined. So you put up the necessary guarantee or security and you get your money, your vehicle back, and then you say to him, now sue me for what you feel is rightfully due to you. So in other words, you would put up a guarantee, substitute that for the lien, and get your vehicle back. What most people don't know is they feel they're obliged to give the vehicle, pay the money,
payment,
otherwise they're not going to get the vehicle. And of course, you're sitting in a catch-22, because what happens is the vehicle is sitting in some storage place, and they tell you every day it's going to be 400 rand or whatever. So, you know, it's worse than being in ICU.
And now you see the fine print, and you see
Yeah.
you signed it, so you
Yeah.
believe that you are bound by it.
So there are remedies available for that. And the remedy really is to put up a guarantee and take your vehicle back.
Okay.
And I think if more people know this, then it'll break that cycle of
And the tow truck drivers won't be able to
unlawful
be
conduct.
unethical.
Yeah.
Look, and okay, we're not saying all tow truck drivers are there, but we know that some of them do it.
Yeah.
And I'm sure there are some tow truck drivers that are ethical.
Sure.
Okay, but a bit of a different type of a question. We know sometimes people go abroad, buy property there, and we know that's happening a lot sort of at the moment. People go to India, go to Australia, go to Canada, go to other parts of the world, and they buy property there. There was a case, for example, where a person went to Australia, bought property there, but didn't sign himself. Somebody in Australia signed on his behalf, right? Can something like that create problems for the person if there's, you know, maybe the person who signed on his behalf claims it, or he can't pay the money for the property? Can they sue him in Australia? How binding is it there? If you are from South Africa, or can they come to South Africa? Let's assume there was a case in Australia, it was successful. Can they now sue you in South Africa based on that case?
Yes. That's a facet of our law called the enforcement of foreign judgments. There's what we call the principle of comity, where basically different countries have an arrangement in terms of the common law where they will enforce each other's judgment. So if you, for example, had a transaction in Australia, for example, and the Australian company then took you to an Australian court and obtained a judgment in Australia against you, then that judgment is enforceable in South Africa. But it's not automatically enforceable because it's not recognized as a judgment of a South African court.
Okay.
So what they've got to do is they've got to take this judgment, they've got to go to a high court in South Africa and say, I've got an Australian judgment, please give me a court order to enforce it here. In other words, to force the South African to pay me what is due to me. And in fact, the court will then look at it and say, here's an Australian judgment, and it will then enforce the judgment. But before it does so, you have an opportunity to oppose the application, to enforce the judgment. Right. Now, the enforcement of that judgment, in considering whether the South African court will enforce that judgment, very important is that the South African court will not enter into the merits of the Australian law or the merits of the Australian judgment. So if, for example, there was something wrong with the decision in Australia, the court will not say, because of that error or wrong principle, or I don't agree with that judgment, that I'm not going to enforce the judgment in South Africa. There are extraneous factors, however, which a court will look at. For example, and a perfect example would be if you didn't get a visa in time.
Correct.
And if you didn't get a visa in time and you didn't attend the court, and the court said, I'm refusing a postponement application, and you asked somebody to ask for a postponement in Australia, and the court then, based on your absence, granted what they call a default judgment against you. So it's a judgment.
Yeah.
While the South African court cannot enter into the merits of that judgment itself, what the South African courts will do is look at the process that was involved. And one of the principles is that when there is a deficiency in the process, for example, the breach of the Audi principle, where natural justice is breached, where a person isn't heard properly.
Wasn't given the opportunity to be heard.
Yeah, then in that case, the court will say, on policy reasons, I'm not enforcing the judgment. So the court will enforce the judgments, but one has to look at the extraneous factors. Was there unfairness in a sense of the process? One of the examples, or public policy, for example.
Okay, probably a good time to take an ad break, viewers. We go for a break. After the break, please be ready with your contributions, with either your questions or any comments or anything that you think is relevant relating to the law that Advocate Ghulam Amir can answer for you. The number will be on the screen. Please stand by. Time for the break. Welcome back. Our guest this evening is Advocate Ghulam Amir. He was previously on the show, so some of you may remember him. We're busy talking about all types of things in the law. We're talking about contracts. We're talking about tow truck drivers. We're talking about buying property. The one that we've got for you now, Ghulam, is about body corporate, because a lot of people are involved in body corporates. Yes. They buy properties, body corporates, or the trustees seem to wield a lot of power, or tenants are not sure, the owners of the properties are not sure what their rights are in relation to the trustees or the body corporate. Take example for the property where you have businesses downstairs, residents upstairs, the business owner downstairs owns the property. And obviously, to really run a good business, sometimes you have to make major renovations, make the place look smarter. And this person decides, I need to renovate. And he starts the renovations because his plans are approved. And suddenly the trustees come and say, wait, sorry, you can't do that. You're not allowed to build without our permission. You can't make any changes. And perhaps not only at that level, but let's assume one of the people in one of the houses want to make major changes. What are their rights?
It's becoming more and more acceptable these days, because of security reasons, to in fact buy within a cluster. And the clusters, it's a very important question raised, because these clusters are often governed by the body corporate.
Okay, Ghulam, can I stop you there? We've got a caller on the line. Caller, please come through with your question. Assalamu alaikum. Hello?
Hello, can you hear me?
We can hear you. Go ahead.
Good evening. My name is Demo from Devon.
Right.
Okay, I've got a very quick question.
Okay.
What I'd like to ask you, our guest, is I'm looking private property, and we were in the waste rental. So what the landlord-
Sorry, can we just stop you? The line isn't very clear. Do you perhaps have the TV on in the back? Could you mute the
Okay.
TV perhaps?
Okay, that's pretty off. Okay, can you hear me?
Yeah, we can hear you a bit better now.
Okay. Okay. With the very arrears and pay the very rent, and the landlord decided to take us to the local magistrate's court for evictions. What I'd like to know is, can the landlord use the PI Act and also without using the Rent Housing Tribunal, the first of intervention from it? And secondly, if not, why did the landlord use the so-called ESTA Act to get us evicted? And the Tellingwood case took the matter on the roll on condition that pay legal fees of up to 12,000 rand. And if you don't pay the 12,000 rand, he will put the matter back on the roll, and then we will be liable for his 40,000 rand legal fees because he is guaranteed assurance that the magistrate would evict tenants of this particular landlord. That's all I want to say.
I didn't want to interrupt, but I heard very little of that
The
question.
question is not very clear.
Are you
No.
calling us from a cell phone?
Yes, I am.
The signal is very poor there, and we didn't hear much of your question. Can you assist maybe if you heard?
I thought you were...
No.
I also didn't want to interrupt you while you were talking. Do you want to try again? It's not coming through very
Let
clearly.
me just understand carefully. You're a tenant somewhere.
Yes, I am a tenant.
Yes.
And I'm living in private property.
You're living in a?
Private property.
Right.
Private property, okay.
Yes.
So I'm one of many hundreds of tenants. And so the landlord decided to take eviction on us. And basically what it was,
I missed
the
that part. Did you
attorney
get it?
took the matter to the court and applied under the PI Act.
Yes.
That's the occupation of illegal lands. So when we questioned this, why didn't the landlord go to rental housing tribunal? He says no, he wants to evict them. So what I'd like to know is, can a landlord use the so-called act, the PI, the Prevention of Illegal Eviction? And there's another act called the ESTA Act, something about property, ownership of property, that occupying the land illegally. So what we decided to do is question the attorney. So he says us, unless you pay my legal fees, I will have no choice but put the matter back on the roll. Because he's got a gun on our head to say that we pay his legal fees. And if we don't pay his legal fees, he put the matter back on the court roll. And he's assured that the magistrate in that particular court evict us, and we will pay the 40,000 rand, his legal fees, despite the fact that we have paid our debts in full.
Okay.
So that's stuck.
I think I got the gist of the question, although it was still very unclear. Yeah. Effectively, what you're asking is, there's an application for eviction of all the tenants, is that correct?
Well, I'm one of the hundreds of tenants.
Okay, and it's not based on a breach, i.e. not payment of rental, am I correct?
Yes, it's part of a breach.
Is it based on a non-payment of rental?
That is correct.
Okay, now the rights of a landlord, and that's again another misconception. Many people, when PI came about, many people were, particularly landlords, were of the view that it's impossible to evict somebody who is a tenant in the house, even if they don't pay rent, or it will take many, many years to get somebody out. That's a misnomer or a misconception. Generally, the law has always been an owner is entitled to possession of his property, and the exception is if he has given occupation of that property to somebody in terms of a lawful lease. So anybody who is in occupation of a property as a lessee is only entitled to remain in occupation of the property until such time as the lease is alive. If the lease comes to an end, the continued right to occupy the property also comes to an end. Now, there are several ways in which the lease can come to an end, if there is one. And I'm not talking about a written lease agreement, even if it's an oral month-to-month lease agreement. If a tenant breaches in one instance, such as in your case where there hasn't been a payment of rental, the landlord is entitled to write a notice and say, please vacate within 30 days, the lease is at an end. And once the landlord does that, then the tenant must occupy. His continued occupation in the eyes of the law would then be unlawful. Now, in the old days, before the implementation or the institution of the coming into the PI Act, before PI came into operation, the landlord could simply go to court, apply for an eviction, and within a matter of a few days get the eviction order and throw the person out with an eviction order. PI is a new statute, relatively new, a couple of years, which has now recognized that even if a person is a tenant and is in breach for not having paid his rental, because of the circumstances of school-going children, elderly people, etc., there has to be some reasonable notice that he has to be given to vacate the property, and the courts have decided to oversee that. But once you are in breach of an agreement, the landlord has the right to go to the court, and the court must grant him an eviction order. It must, because it's his right to do so. If the court doesn't do so, the court would be acting, would not be giving effect to the law. But what the court will do is will say, unlike in the previous dispensation where I could give an immediate eviction order where you must be vacated today, the court will say to the tenant, I'm giving you 30 days to leave. If within the 30-day period you haven't left, then the sheriff is entitled to come in and to remove goods and to evict the person. So PI is simply a process